Project, American University, Washington College of Law. Thank you all so much for joining us today, and again, I apologize for the late start. So we are, just before we get started, I wanted to let you know you can ask questions in the chat throughout the webinar, and I will be responding to as many as I can orally during the presentation. In addition, our Deputy Director, Rocio Molina, is joining us, and she will also answer questions in the chat, and she can answer them for the interpreter who's on the line. She can answer them in either English or Spanish. So as we get started today, I want to thank the DC Office on Victim Services and Justice Grants for hosting this and for helping us advertise and welcome you all here on behalf of them and us. Today, our learning objectives, we're going to, by the end of this webinar, you'll be able to quickly identify victims and their children who qualify for publicly funded benefits and services, and you'll understand the connection between immigration relief and public benefits. And so as victims file for immigration relief, more victims become eligible for public benefits and services. And we'll be talking a lot about that, and we're going to give you some hypotheticals to work through so you can see how that works. And finally, or firstly actually, we're going to start off also talking about how Violence Against Women Act confidentiality protections from removal, protect victims from removal, and how it improves safety planning to understand those VAWA confidentiality protections and when they kick in, and how they improve both safety and access to justice for immigrant survivors. But just to get started, I want to start with our first poll. We're going to do several polls, and so if we can have the first poll, if you could tell us, I'd like to see who's on the call today. So check the boxes that reflect who you are so we can get a sense of what the audience looks like. The options are victim advocates or coalition staff, attorneys, and then folks that work for police, law enforcement, prosecutors, police, sheriffs, and their victim witness staff. So they would all go together. And if it's other, if you could check other and then type who you are in the chat box so we could get a sense of that. So it looks like we have about, so far, I'll give you a couple seconds to respond, that about half of you are victim advocates or coalition staff, about a little more than 20% of you are attorneys. We have 27% other, and about 6% of you working in prosecution or offices or as victim witness staff for prosecutors and police. Great. Can end this poll. And so, great. And so for those of you that, let me just see if I can see what people are saying they're coming from. Those of you that are said other, if you could type in the chat what you are, that would be great. While we're doing that, we're going to go on to, I'm going to start off with a little bit of information about demographics of immigrants in DC. And what you'll see is about 13.8% of DC's population are people who are foreign-born. Of those, 37% are either here on temporary, some kind of temporary legal visa, or they're here as undocumented immigrants. 36% are naturalized, and 27% are lawful permanent residents. And that you've seen a 33% rise in the immigrant population over the last couple of decades, with almost a third having entered after 2010. And that also explains why you have about 16.9% of people in DC who speak a language other than English at home, and 39% of your foreign-born population are limited English proficient. What's also important to understand is that children in the district, 23%, over 23% of the children in the District of Columbia have one or more immigrant parents, which is a significant number, and over 80% of those children are citizens. So my next question, and if you could please type your answers into the chat box, is what are the 5 top languages other than English and Spanish that you think people are speaking at home in DC? Amharic, ASL, French, I'm seeing. Amharic, Chinese. Good. Give it a few more seconds. Yeah. So you guys look like you're on it. Your French is actually the second. French including Haitian and Creole, Cajun, Haitian, Creole, all of that. Amharic, Somali is the third. Chinese is the fourth. Arabic is the fifth. And would anybody have guessed German? This happens all the time. Everywhere I go around the country, this German number squeaks in there in really strange ways. But yes, German is the 6th, I guess you could say, or the 5th on that list. And when you look at countries of origin, what you find is in the district, obviously the biggest group are people who speak Spanish, who are Latin American from various parts of, with a heavy emphasis on Central Americans, people from the Caribbean, and people from El Salvador and Central America, much less than Mexico. But what's really interesting here and very different than a lot of other places is African immigrants, European immigrants, and Asian immigrants are almost the same numbers in DC. And then the next highest is the Middle East, and you have some Canadians. So that's a very interesting mix of people from different cultures and you'll have people with different immigration statuses, etc. So what we're going to do is we're going to start open with a very brief overview of the forms of immigration relief that immigrant victims are eligible for. And we're going to start there, and then I'm going to quickly, after we kind of go over some of those, is I'm going to connect them to what it means for public benefits as we go through this. But basically, Congress created a number of forms of immigration relief that were designed to increase victims' access to justice, both the criminal justice and the civil justice system, enhance protection for victims, and improve community safety as well. So there were lots of different purposes behind these immigration provisions, in addition to helping victims. And that gaining legal immigration status protects victims from deportation through Violence Against Women Act confidentiality, which I'll be talking about. It also allows people to sponsor family members that can be included in the application. It gives people access to legal immigration status and financial independence from the perpetrator. Work authorization is actually running now between 4 months on the short end for trafficking victims and VAWA self-petitioners, and 6 years on the long end for U-Visa people applying for U-Visas. Also gives them access to a federally recognized ID, and it's a key to how additional public benefits. This is a chart. This is a tool. It'll be on the website and the materials. It's actually live. If you click on the black circles, it takes you to the forms on the DHS website, the Department of Homeland Security website. And if you click on where it says U-Visa or SIJS or VAWA, it takes you to the landing page on the Department of Homeland Security website that describes the program. But this is a good summary of the kinds of immigration relief many immigrant victims that you'll be working with, children and adults, will qualify for. And the ones we're going to predominantly be focusing on today are remedies for trafficking victims, primarily the T visa. They also have something called continued presence that law enforcement officials and can request for victims. We're going to be talking about the U visa for crime victims, VAWA self-petitioning for people abused by their U.S. citizen or lawful permanent resident family members, and special immigrant juvenile status for children who've been abused anywhere in the world by one or both of their parents. And another way to think about it is For those of you that are immigration lawyers, you'll recognize most of this as the U visa list of criminal activities. But it also, when you look at it as a whole, anybody you're working with who is an immigrant, who is a victim of any of these types of criminal activities, and I'm including in this child abuse, abandonment, and neglect, then they will likely qualify for some form of immigration relief. So I'm going to start by very briefly talking about the VAWA self-petition. And again, we're going to be focusing on issue spotting here and the timing, because you can help as victim advocates and attorneys, victim witness staff, knowing how they differ in terms of how quickly it creates a path to stability for victims is really important. The VAWA self-petition is basically for someone who has been battered or subject to extreme cruelty, and that is the way domestic violence is defined under immigration law. I'll explain that more in a minute. By a U.S. citizen or lawful permanent resident, parent, step-parent, spouse, former spouse within 2 years of death, divorce. They have to have resided for some period of time together, and have if in fact it's a relationship tied to a marriage, like a spousal relationship or a step-parent relationship, they have to show that the marriage was in good faith. But basically, if somebody has been abused by their U.S. citizen or lawful permanent spouse, spouse, parent, or over 21-year-old citizen child, they'd be eligible to VAWA self-petition. They also qualify likely for either a battered spouse waiver or VAWA cancellation, which is the defense in immigration proceedings. And these cases, they get prima facie determinations within 3 months of filing, and they get work authorization within 4 months of filing if they're married to citizens, or if the perpetrator is a citizen, and up to about 18 months of filing or 2 years of filing if the perpetrator is a lawful permanent resident. And that battery and extreme cruelty basically includes anything that would be defined as domestic violence for either protection order or criminal purposes in D.C., plus these types of emotional abuse. And some of you may recognize this list. It usually is round. This is actually derived from the power and control wheel. But the definition is broader. So it means that if somebody is married to a U.S. citizen or lawful permanent resident and they're experiencing these types of abuse, then this extreme cruelty can be sufficient for a VAWA self-petition, and they don't have to wait until the first battering or sexual assault. But for victims who where the abuser is not their U.S. citizen or lawful permanent resident, spouse, parent, or citizen child, then the U visa is an option, which is an option for victims of criminal activity. And that's that broader list I showed you a little earlier, which includes domestic violence, many different kinds of sexual assault, child sexual exploitation, child abuse. It includes kind of hostage, people being held hostage like criminal activities, murder, manslaughter, and things like that. The victim here has to either have been, are being, or likely to be helpful in either the detection or investigation or prosecution or conviction or sentencing of the criminal activity. They have to show that they've suffered substantial harm because of the criminal activity, and that the abuse occurred in the United States. These cases, it's a 4 to 6 year wait until they get work authorization, driver's licenses, and things like that. It's a much longer wait until they get benefits. U visa victims get benefits, it's almost like over 20 years because they have to obtain the U visa and obtain lawful permanent residency before they become benefits eligible. And once they get for some benefits, it's 5 years after they become lawful permanent residents. Trafficking victims, however, have the greatest access to benefits and services. To qualify as a trafficking victim, you have to be a victim of a severe form of trafficking. It can be either sex or labor trafficking. It can involve either a victim under the age of 18, or for an adult, there has to be force, fraud, or coercion. They have to be physically present in the United States. Same thing for U visas. VAWA self-petitioners, if you were, let's say, abused by somebody in the military, you could have been abused abroad and qualify. And the victim has to comply with reasonable requests for helpfulness in the investigation or prosecution of the trafficking. And there's some exceptions to that compliance for under 18-year-olds and victims who suffer psychological or physical trauma that impede cooperation. Work authorization and many public benefits come as quickly as 3 months to 12 months in these cases. So it comes much, much more quickly than other cases. And we'll talk about ways that sometimes there are trafficking cases that overlap with our domestic violence cases, and we'll talk about that in a minute. So special immigrant juvenile status is another major form of relief. Many of those U visa victims that we were talking about a few minutes ago, U visa victims who are in that 20-year line for their visas, their children, if it was, let's say, the father, they're not married, and or it doesn't matter if there's marriage, but basically the parent and the father of the child abused both the mother and the child. And in that case, there'd be a U visa for both of them, or the child could additionally file for special immigrant juvenile status because that child was abused by one of their parents. They have to be, it's relief for unmarried children under the age of majority in the state, which I believe is 18 in D.C. You can type in the box if I got that wrong. Victims, they have to show that they are either victim of child abuse, child abandonment, or child neglect, as defined by D.C. law. And abuse has to have occurred by at least one parent, not both parents. And they could be living with the protective parent. The timeline to approval on these cases is 6 months to 3 years, depending on the country of origin. But many children will receive special immigrant juvenile status and lawful permanent residency based on special immigrant juvenile status much, much, much faster than they would if the U visa is their only other option. So the other thing that's important is that is to note is that that people can include, so children can be included. So children who are victims can include their parents in their applications if they're applying for T visa, U visa, or VAWA. Parents can include their children in their applications if they're applying for one of those remedies. Children applying for special immigrant juvenile status can't include any of their family members. So that's a difference between those. What's important, so that when people file VAWA, self-petitions, U visas, or T visas, they get immediately some protection through VAWA confidentiality, and we'll be talking about that in more detail, to protection from deportation, that applies immediately. They get a path to legal work authorization and a driver's license upon approval or waitlist approval. And as I said, that usually comes, depending on the case type, within 4 months to 6 years. And they get some access to federal public benefits. Now, we're in the District of Columbia. And D.C., Maryland, and Virginia, the whole DMV area, it's important to note that there are differences. What benefits and services, benefits in particular, state-funded benefits, a victim will get in D.C. are different than Virginia and are different from Maryland. And we have a way for you to look them up, because I know that sometimes, like if you're working with a victim and she's going to leave an abusive home and relocate, it'd be important to do an analysis if she's trying to decide, for example, between Maryland and Virginia or another home in the district. The benefits implications of that choice are important. I'm looking at the SIJS question. For SIJS, what if they're Okay, so for special immigrant juvenile status, if they're over the age of majority in the state, it is the age of majority in the state that controls access to special immigrant juvenile status. So if they missed that deadline and they were abused, let's say in DC, they would probably have to file for a U visa as another option. So what we're going to do, I know this is overwhelming, but I'm going to read you a case scenario that will help you see actually how easy it is to detect who qualifies for what, which is what you'll need to do in terms of getting victims to resources in your area to help them apply and to help them, be better eligible in terms of public benefits. So here's the scenario. Clara met Eduardo, a lawful permanent resident, when he came back to his hometown to visit his family in El Salvador. Eduardo started dating Clara, who was raising her then 9-year-old son, Miguel. After Clara became pregnant and gave birth to a baby girl, Lupe, Eduardo decided to bring Clara, Miguel, and Lupe to the U.S. to live with him in D.C. When they arrived in the United States, Eduardo took Clara, Miguel, and Lupe's passports and became physically and sexually abusive of Clara and abusive of Miguel, who tried to protect his mom from Eduardo's abuse. Eduardo also physically beat Lupe when she misbehaved. Within a year following their arrival, Eduardo forced both Clara and Miguel to work for his family business and never paid them for their labor. One night, when Miguel was 13 and Lupe was 5, Eduardo's rage led to severe beatings with a belt of Miguel and Lupe. When Clara intervened to protect the children, Eduardo strangled her until she passed out. The neighbors heard the commotion and called the police for help. Clara talked to the police when they arrived. The police arrested Eduardo for attempted murder and child abuse and took Clara to the hospital and placed the children in the care of the state. So we're now going to do 3 polls to see how you can identify what people might qualify for. So what forms, and if you could answer the poll, what forms of immigration relief would Clara qualify for? A U visa, a VAWA self-petition as the parent of Lupe, a T visa, or all of the above? I'll give you a few moments to think about it based on the scenario I just read you. Looks like we kind of have, so it looks like 70% of you are saying VAWA self-petition, 15% of you are saying all of the above, and 5% of you are saying U visa. So the answer is all of the above, and let me explain why. She is and you can end the poll, thank you very much. So she qualifies for a U visa because she was a victim of the strangulation and the domestic violence in the U.S. She qualifies for a self-petition as the parent of Lupe because the father of her child, Eduardo, abused the child, and she can file a self-petition as an undocumented mother to protect a child, even if that child was, let's say, a citizen. In addition, though, if Eduardo, because the key here is we didn't know in the facts, they didn't say whether Eduardo and Lupe were married. Eduardo and Clara were married. If Eduardo and Clara were married, then she could self-petition in her own right as a wife of a lawful permanent resident. She's eligible for a T visa because she was forced to work for the family business and not paid for her labor. So it's actually all of the above when it comes to Clara. So now let's see if we can figure out what Miguel qualifies for. So can we have the third poll, please? And so this poll is, what forms of immigration relief would Miguel qualify for? VAWA self-petition, U visa, T visa, SIJS, or 2 of the above? I'm making these 2 a little bit harder. And for those of you that write 2 of the above, can you type in the chat box which 2? So we're seeing people vote. It looks like about 5% have said U visa and self-petition, 0 say T visa, 11% say SIJS, and 77 say 2 of the above. So let's end the poll and see which 2 you guys say it was in the chat box. Anybody type in? C and D. So he qualifies for a T visa, but he doesn't qualify for SIJS because there's no marriage between his mother and Eduardo. If there was a marriage between his mother and Eduardo, he'd qualify for SIJS. The answer is he qualifies for a T visa and he qualifies for a U visa. And if there was a marriage between his mother and Eduardo, he'd also qualify for a VAWA self-petition. But this is how you can see how these are all related. And the last one at this point, poll 4, please. So what forms of immigration relief would Lupe qualify for? And the choices are VAWA self-petition, U visa, T visa, SIJS, and then we again have 2 of the above. And while we're collecting votes, we'll have you weigh in on which 2. So it looks like almost all of you, 90% of you or 85% of you are saying 2 of the above, and about 11-12% of you are saying SIJS. Okay, we'll end the poll and see what you said in the chat box about which 2. It's actually, I lied. I missed an edit here. It's actually, is it a trick question? Anybody get it here? The trick question is actually 3 of the above. So Lupe qualifies as a VAWA self-petitioner because she's abused by her lawful permanent resident father in the United States. She qualifies for a U visa based on the same abuse, the beating with the strap, or for her mistreatment. She qualifies, Emily Wu got it right. She qualifies for SIJ because it was her parent, Eduardo, who abused her. And she doesn't qualify for a T visa because she wasn't trafficked. Her parents were trafficked. I mean, her mother and brother were trafficked. So that's how it works. And you can see there's various forms of immigration relief, which from public benefits perspective, choosing which one you choose makes a true difference. Great. So, and let's talk about that difference. So when you think about the kinds of immigration options each of them have, and so for example, if Clara files for a T visa, she could include both of the children in her application. If Clara files, if she files a self-petition as the mother of Lupe, she can include Lupe and Miguel in her application. And that's kind of how it works. So what it means in benefits purposes is you can see that for TANF payments in D.C., T visa is the only way that you get them immediately. VAWA self-petitioners have a 5-year and 3-month wait. SIJS have, basically whatever number of months it takes them or years it takes them to get the SIJ granted, then they have to wait 5 years. And U visas have to wait until they get the U visa, which is about 21 years, and then wait 5 years. Food stamps are a bit different. So food stamps, again, trafficking victims, Clara and the children in this case, if they applied for T visa, would be immediately eligible for SNAP. If the children, if they went, so if Clara filed a self-petition as the mother of Lupe and included Miguel, it would take Miguel and Lupe about 3 months to get eligibility for food stamps, although Clara wouldn't get them. Clara would have to wait 5 years for her eligibility personally. And children, if Lupe filed for special immigrant juvenile status, it would be a wait of 1 to 3 years to get SNAP because they have to wait until the child gets lawful permanent residency through SIJ. For housing, and we're talking about public and assisted housing here, it's a bit different. So VAWA self-petitioners and T visas are exactly the same. So the moment they file, basically VAWA self-petitioners get it the moment they file, they're eligible for public and assisted housing. Trafficking victims, it's about 3 months after they file. But the way a special immigrant juvenile status child could gain eligibility to a public or assisted housing unit on behalf of their whole family, but it would be at the point at which they got lawful permanent residency. And you can see that there's a long wait for housing for U visa victims. Post-secondary educational grants and loans are available immediately to trafficking victims. Both the VAWA self-petitioner and the children included in the application have only a 3-month wait to FAFSA under VAWA. It is at the point of lawful permanent residency, which is 1 to 3 years for SIJ and 21 years for education for U visas. But you'll see, though, there's a difference because education you get as soon as you become a lawful permanent resident. So U visas only have a 21-year wait, whereas they don't have the extra 5 years like they have for food stamps and TANF. Okay. So now what we're going to do is change over to VAWA confidentiality protections. And I'm going to explain a little bit about what VAWA confidentiality does for victims. Okay. So the next poll is to ask you, check A, B, or C. Have you worked with survivors who have received either threats of we're waiting for the poll. Here we go. Threats of deportation from a perpetrator. They've been contacted by immigration officials, or both. I see there's like a few of you, like 4 of you so far. Let's just wait a few minutes or a few seconds. So it looks like, trying to do my math in my head, 17 of you so far are reporting that this has happened, maybe 19, 20-ish. Okay, great. It's not great, actually, but we can move on from the poll, Vern. So, sorry, it takes me a second to get my cursor back here. So yes, this is a common phenomena, and one of the things when I talk about, there's not only public benefits reasons to screen victims for immigration relief and apply quickly so that they can get access to public benefits sooner, but also we know that 25% of perpetrators in U visa cases and almost 40%, just under 40% of perpetrators in VAWA self-petitioning cases are actively involved in trying to get victims deported. And they do this by picking up and calling the phone, trying to report them to DHS. And they also do it by, particularly when limited English proficient victims call the police for help. If the police don't have language access effectively at the scene or not providing it, perpetrators are very effective, and that's what this data shows, in getting the victim arrested. And so that can happen as well by local law enforcement. VAWA confidentiality essentially does 3 things, and I have different kinds of slides for your reference here. I'm not going to go into great detail, but it prohibits the government from relying on perpetrator-provided information, and I'll explain in more detail what that means. It protects certain locations, like courthouses in connection with domestic violence, sexual assault, human trafficking cases, child abuse cases. And when a victim files an immigration case under VAWA T or U visa protections or the battered spouse waiver, the records are essentially sealed, and I'll talk about what that means and the limitations of it. Here's another way to look at it. And what's important is the non-disclosure protections apply the moment somebody files a case with the Department of Homeland Security. The not relying on abuser-provided information protections applies the moment there is a parent-spouse relationship, a parent or a spousal relationship, and there's abuse, or to all victims who are in the process of filing for a T&U visa. And the locational protections apply to everybody who's a victim. So what happens is the moment somebody files an immigration case, it gets flagged in a special system at the Department of Homeland Security that reminds immigration officials that this is a victim of domestic violence, and generally speaking, it should be hands off for removal, or there is a long process a complex process which includes going up the chain of command that an immigration official is supposed to go through to be able to go after a victim. And it gives you an example of the language that in the Department of Homeland Security policies on this. And they basically say if an employee receives adverse information from a spouse or family member, or even a, quote, unknown private individual, they're supposed to check this system and be aware that if the system is flagged, there could be a victim-abuser dynamic at play, and that they shouldn't be doing enforcement actions, at least not without getting permission up the chain of command from supervisors. And the bars on relying on perpetrator-provided information means that the government can't reach out and get information or rely on information from any of these persons. So a sexual assault perpetrator, a trafficker, a perpetrator of a U visa crime, one of their family members, or somebody who's closely associated with the perpetrator, or the perpetrator themselves. And that adverse action means they can't use that information from a perpetrator to deny a victim's immigration case, to detain or deport or initiate an immigration action, or even stop and question a victim. And they can't contact an abuser, seek information from an abuser, call them as a witness, or rely on anything that they provide to harm the victim's immigration case. And they can't, and this is again the policies, they can't rely solely on it. So if the tip is she's a felon who's murdered 3 people, the victim is going to turn over as part of her application fingerprints, and they're going to know that anyway. So that's not information. They might get the tip to go look at the fingerprints, but they would have looked at the fingerprints otherwise. So in terms of relying on the information about her criminal history, that will come from the fingerprints, not solely from the abuser. But they say that this adverse information is inherently subject, and that if an officer believes there's any credible evidence that the alien may be eligible for VAWA benefits or TRU, confidentiality applies. And this is ICE policies in place since 2007. So VAWA confidentiality, who does it protect? It protects VAWA self-petitioners, VAWA cancellation, VAWA suspension, battered spouse waiver applicants, T visas, U visas, and it covers, some of you might be, because this is in D.C., there's a form of immigration, there's basically, some of you might be working with spouses of work visa holders, people who are diplomats, people who have H-1Bs, people who might work for international organizations. Their spouses have kind of derivative visas. They have visas that come with the status of the working spouse. Those spouses aren't generally eligible to work, but if they're abused, there's a special work authorization application option for them as abused spouses of these work visa holders, and VAWA confidentiality applies to those cases as well, including the deportation protections, because those cases will all be cases involving a marriage. The statute does not require that that these people are protected without regard to whether an immigration case was filed, which generally means victims of spouse abuse, child abuse, parents of child abuse victims, etc. But it's better always, as a practical matter, the protections really only apply when the protections really only apply when the victim has actually filed for immigration relief. Can you answer a question if you missed? So I think I was asked, you can't apply for SIJS when you're over the age of majority in the state. There's some litigation going on about that, but generally speaking, I think I've answered that. Okay. So, where am I? Okay. So the non-disclosure provisions of VAWA confidentiality prohibit disclosure of any information. So once somebody files a VAWA, a T, or a U visa case, nobody can find out, not anybody, I mean, unless you are with very strict limitations within the Department of Homeland Security, sometimes not even, ICE and Immigration and Customs Enforcement or Border Patrol, they can see that it's a victim's case, but they can't tell whether it's a VAWA or trafficking victim or domestic violence victim or child abuse victim. That information isn't available. And that to the general public, including anybody outside the Department of Homeland Security, the Department of State, or the Department of Justice, they can't see anything about this case, about the existence of the case, actions taken in the case, information contained in the case, and it's not disclosure to anybody. And this limits discovery in family court and criminal court cases. They can't discover information either, with the exception, the only thing that's discoverable is the certification in the U or T visa case, and it's the certification itself, not the entire file, or what happened in the case. And these protections apply forever unless the case is denied on its merits. So they're very potent in that respect. The locations that are prohibited in terms of immigration enforcement for victims include these. Pretty much most of your programs: shelters, rape crisis centers, visitation centers, family justice centers, victim service providers, community-based organizations serving victims, and courthouses in connection with a protection order, custody, civil or criminal case involving or related to domestic violence, sexual assault, stalking, or human trafficking. And these give you some more detail on what these directives say about, how strong the protections are against actions at confidentiality protected locations. It's also important to note that there are other sensitive locations under immigration law, and this may be important if you're working out, for example, child visitation. Immigration enforcement is not supposed to be taking place at schools, medical or medical or healthcare facilities, places of worship, religious ceremonies, etc. If VAWA confidentiality is violated, the agent who violates the VAWA confidentiality can be subject to job sanctions. There's been a lot of job sanctions imposed, and they can be individually, personally responsible to pay a $5,000 fine. VAWA confidentiality can also be, we are the lead nationally on VAWA confidentiality. So if you are working on a case and a VAWA confidentiality violation has occurred, you can call us, and we've been very successful in getting the Department of Homeland Security to cancel notices to appear, to dismiss immigration cases against the victim, sometimes to expedite processing of a victim's case as a remedy, and immigration judges are authorized to dismiss cases in which VAWA confidentiality violations have occurred. But it's quite complex getting that happen, and we do case-by-case technical assistance on that issue. What's going on? Why is my screen not switching? Hold on. Okay. So the next slide is a poll. Has a perpetrator in a family court case you have worked on tried to raise the immigration status of the victim in the case, or obtain information about the victim's case through family court discovery, or both? And we're seeing that a few of you, like a handful of you, are reporting that this is happening. Okay, Vern, thank you. So what you're talking about, it looks like 10 of you have said roughly that you're seeing this. This is actually quite common nowadays. As in recent years, as anti-immigrant sentiment has gone up, perpetrators are starting to raise issues in immigration cases more commonly, particularly trying to get discovery. And we provide technical assistance and have lots of training materials on this to help you if this is happening in a case. Please call our technical assistance line or send us an email. We get back to you within 24 hours. This is a duplicate, I think. So let me go back. So yeah, and we can provide technical assistance on that. So best practices in advocacy, and this is the last issue on confidentiality, is that knowing that a victim can be protected against deportation means that if you screen for immigration relief eligibility, and this is why, for example, let's say you have a child abuse victim and the perpetrator is threatening to get the mom deported if she reports the child abuse. And the child abuse is perpetrated by the father. And the mother could file a U visa on behalf, she's undocumented. The child could be, let's say the child's also undocumented. The child is eligible for SIJS, but they're also eligible for a U visa. SIJS does not give them VAWA confidentiality protection, but the U visa does. So mom could file, or the child could file for U visas, get VAWA confidentiality protection from deportation, and the child may ultimately get their green card through SIJ, but they remain protected by VAWA confidentiality for the rest of their lives. Because their U visa case was never denied on its merits, it would be denied because they didn't need it, because they got their immigration status through SIJS. It's best practices to give the survivors that you're working with, as soon as you realize they're eligible and they're going to start applying, a letter saying, it could be from an advocate or attorney saying they're applying for a U visa, they're applying for VAWA, they're applying for a T visa. And that letter, the victim should carry around with them and give to ICE or CBP, whoever, if they're stopped by any immigration official, they should hand that piece of paper. And that will trigger VAWA confidentiality, and it really does. I've worked on cases where this absolutely works. It takes good advocacy, and you'll have to call us and we'll walk you through it and work with you and partner with you on it. But we've been able to unravel many of these cases. And that what we also know is that when victims and that it's important to screen before a victim gets a protection order or a custody case, because what we're also seeing is that when you file the family court case, the perpetrator will retaliate by trying to turn her in. That's one of the points at which he'll start calling ICE. So if she's already in the system, she's better protected from immigration enforcement than if she files after she's been turned in. So that's one of the things as you think about how, when you're doing your safety planning with victims and you're doing your case strategy, you want to think about getting a file into that system that is well documented, because you don't want to file a case that's not well documented, because ICE or USCIS at this point in time is denying on cases that don't meet the prima facie test upon filing. So you don't want to file an incomplete case, because then you'll end up with a denial, and then they'll turn denied victims in for removal. So it's important to avoid that. And the question from Brenda, which I think is a good one, as to SIJS, the neglect, abuse, or abandonment, if it's an SIJS case, can happen anywhere in the world if it's perpetrated by a parent. So SIJS, they are eligible whether the abuse, abandonment, neglect occurred in El Salvador or incurred in D.C. For VAWA U visa, it has to have occurred in the United States. T visa, it has to have occurred in the United States. There are situations in which U visa, VAWA self-petition, the abuse could have occurred outside of the United States. Okay. So now we're going to go and we're going to spend the rest of our time digging deeply into public benefits, more deeply into the details of the public benefits. So I'm going to start with an overview of what victims qualify for without regard to their immigration status, okay? So all victims, VAWA, T, U, SIJ, SIJ children, this would qualify for, this would mean, so when we talk about legal services, anybody who qualifies for VAWA, T, or U, or eligible for, qualifies for it, even if they don't apply for it, are eligible for LS, Legal Services Corporation funded legal services without regard to their immigration status, and for anything related to the abuse. SIJ children are eligible for that same same representation if they can show, if they were abused, if they were, they'd have to fall within battering or extreme cruelty. And there's certain forms of neglect that would qualify, and certain circumstances where abandonment may qualify for extreme cruelty. But that's the edge there. And we have lots of materials on legal services if you want more. But everybody qualifies for family court, for language access, police assistance, protection orders, custody and support. They can have their abusers criminally prosecuted. Undocumented parents who don't themselves qualify for something can apply for public benefits their citizen and lawful permanent resident children qualify for. Everybody qualifies for victims of crime VOCA assistance in D.C. and pretty much all but one state in the U.S. Shelter, transitional housing, WIC and the school lunch program, immunizations, primary and secondary education, and healthcare from community and migrant clinics. And they also qualify for any services that were on the Attorney General's list of required services that are necessary to protect life and safety. And those are services provided in kind at the community level, not based on the individual's income and resources, and that are necessary to protect life and safety. And it's a quite robust list. I think we talked about this. They also are eligible for emergency Medicaid, immunizations. Emergency Medicaid, by the way, includes all COVID-19 treatment and COVID-19 testing, free of charge. In-kind services necessary to protect life and safety include this list. So all your adult and child protective services, crisis counseling and intervention, abuse and prevention and violence prevention, victim assistance, treatment of mental illness or substance abuse that is necessary to protect life and safety, and then help during adverse weather conditions, soup kitchens, shelter and transitional housing, nutrition programs. It's food banks and community food banks. It's a quite broad list. As to the question about whether we have a flow chart to help you see, we have flow charts on benefits access for VAWAs, T's, and U's based on their status that we can provide you. We will add those. I'm asking Gwen and Rocio to make a note, and we'll add them to the webpage of materials that we're distributing. So when you check tomorrow, they should be up. If a child qualifies, a parent can go and make that application for the child. And in fact, the laws around this are quite clear. When you go in as a parent to apply for a child, the benefits workers are not supposed to ask you any questions about your immigration status or your social security number, the parent, only about the child, unless you're seeking additional funding for yourself. And this is one of the reasons that benefits workers often don't know this, and the chances that an eligible VAWA self-petitioning victim who goes in to file for benefits will actually get what they're eligible for without an advocate or an attorney assisting them in the application process is very high, very low. I mean, the chances that they'd actually get it right, because this is complex. And we have tools for you that I'm going to be showing you later that you can use to actually print out everything you'll need for that individual client with the law showing why they qualify to hand to the benefits worker in advocating as you accompany them in the benefits applications. So it's really important because that accompaniment helps you build relationships with the benefits workers. It helps them learn who qualifies for what in terms of immigrants, because it's quite complex. In DC, it's a little easier around some things like healthcare, but other things like TANF, it's still complex. And it makes sure that people, children and the survivor, get access to what they're legally entitled to. And it helps make sure that undocumented parents successfully file for benefits that their children qualify for. Because what happens is state welfare workers have federal reporting requirements to the Department of Homeland Security that are actually quite narrow in terms of who they're supposed to report, but there are problems. I mean, an example of the kind of problem that can come up is they're only supposed to ask for the immigration status or the social security number of a parent who's not seeking food stamps, let's say for herself. So let's go back to Clara. Clara is going in to apply for food stamps for Lupe, who's, after she's filed the self-petition or the T visa. Clara is not asking for food stamps for herself. She's just asking for food stamps for, let's say, Lupe and Miguel, who are both, let's say they're included in the self-petition or they're included in, let's say self-petition. So if they were married, they'd both be eligible for self-petition. What the benefits worker is supposed to say to the Clara when she applies and says that, if they're going to ask her questions about her immigration status or social security number, they're supposed to say, I'm going to now ask you a question that if I ask you this question, the information you provide, we must, by law, turn over to the Department of Homeland Security. You have the right to answer or not this question before I ask it. So then ask the question. But we know that benefits workers are not doing that, which is why having an advocate there to make sure she's not asking for anything for herself and to remind the benefits worker that when she's not asking for anything for herself, they don't have to ask her questions is really important, and why advocacy is needed. So we have this interactive benefits map that you can go to, and this becomes very important. Remember earlier I was talking about this is how you can see the difference between DC, Maryland, and Virginia. So when you click on this map, you basically get a web page that looks like the left-hand side of the screen. It says benefits, maps by benefit. And so you look up TANF and you click on TANF and you get a TANF map that looks like this. And then you click on the state you're interested in. Down below, it will say trafficking victims eligible. VAWA self-petitioners eligible with conditions. U visas not eligible. So you can screen right immediately and see, before you go any further, who qualifies. And then what happens is, and the benefits map topics that we cover, we have a map for every single one of these benefits and services. And so you can look up everything, and these are basically government-funded benefits and services. Some have restrictions, some don't. And you can see by benefit, by immigration status, who in your state qualifies. Then, for DC and Maryland, we created these cheater charts, really simple charts. So you can get this on the map, but you can also print this out from your materials where you can see and you can compare by immigration status the difference in DC. This is actually, I think, a Maryland picture, but whatever. But it'll look like this, the difference between who qualifies for what. And that's the basic information. Then what will happen is if you have a client who is eligible, we then have state-by-state charts that you can go to. So that at the bottom of, hold on one second, just go back a couple of slides. When you're on the map, you'll see people eligible, not eligible. At the bottom of the page, they'll say, click here for the DC Public Benefits Map. And that will take you to about a 40-page document where it will look like a much longer version of this chart. It's organized like this. And it has all the footnotes that have all the law that you need to explain to a benefits worker why your client qualifies and show them the government materials that prove they qualify. And it has the links to government websites, all the citations, everything you need to go advocate. In addition to those state-by-state charts, we have charts on state-by-state charts or a chart that lists every state where you can look up how to apply for a VOCA for a battered immigrant, what a battered immigrant qualifies for in terms of, or a sexual assault victim or a trafficking victim qualifies for in terms of emergency Medicaid in your state or jurisdiction. The forensic exams that are available and how payments are made, and what prenatal care and child health care is available. And this is, again, in these charts, you can compare DC, Maryland, and Virginia like you can in the other charts we were talking about. So we have lots of different tools you can use to make the identification of public benefits that people are eligible for easier for you. So what would you take with you to a benefits agency if you were going with an immigrant survivor to apply for public benefits that she was eligible for? Choice A is a copy of the statute, the federal benefits statute, or state. Some places are state benefit statute, so state, or you want the state benefits or the federal. The DHS documents showing that the victim is eligible, and the relevant state or federal public policies, or all of the above. I'll give you a few seconds. And thank you guys so much for participating in these polls. It really helps us. Looks like most of you are saying all of the above. Thank you, Vern, for the poll. And the answer is all of the above. So through the state chart for DC, you can get the statutes, federal and state. You'll get federal and state policies, and the various forms of immigration status come with a DHS document. So a VAWA self-petitioner will have a prima facie determination letter. If somebody is a T visa victim, they could have they'll have a letter from HHS saying they're eligible for benefits. That will come either because they applied for a T visa. Sorry, that would come because they applied for a T visa, or because they applied for, or law enforcement got federal law enforcement officials to apply for a continued presence for that trafficking victim. For an SIJS child, for purposes of health care, which actually isn't relevant in DC because they get health care anyway. But if they want to show eligibility for health care, they'd show their SIJS application. For a SIJS child who might be looking for post-secondary educational grants and loans, they'd need to show their green card, basically, because they're not eligible until they get lawful permanent residency, or green card of the stamp in their passport. And we can walk you through what these various, what you'd actually show for each of these. But usually in the immigration application process, the victim will have some kind of a paper, and you can check with us to make sure that's sufficient in terms of eligibility. So I'd like to go back to the chat box for a second. So Gwen, I'd like to ask you to put the links that you're putting in the presenter chat in the main chat. And I also would like to ask you all to answer this question in the chat. Where can immigrant survivors receive health care that is subsidized without regard to immigration status in DC? Do we have anybody? Just take a moment, and I'm going to say in DC, and then we can talk about Maryland and Virginia as well, so you can know. I'll take a drink of water while we're waiting. Yes, a couple of you typing. So one person had said a federally qualified health center. That's correct. Got to see what other people are typing. Everybody's typing at once, so I have to wait. Okay, I'm going to go on. There's time, and we'll see what comes up in the chat. Unity Healthcare. Yep, there could be other places. So federally qualified health centers are open to everybody without regard to immigration status. So that is a place you can go. That would be true in DC, in Maryland, and in Virginia. You just put in the zip code of the victim into one of these websites, and you can look at where they can go to get health care. And the website, I don't know if it still looks like this, but I think at one point it looked like this. You can also check to see whether the hospital, a local hospital or program is obligated to provide low-income care through the Hill-Burton laws, and you can look that up as well. Federally qualified health centers offer primary care, diagnostic care, all of these different health services, well child services, emergency, medical and dental, preventive care, family planning, pharmaceutical services, mental health treatment, substance abuse. So it's a quite broad range of services that are available through the federally qualified health centers. Emergency Medicaid is also available to everybody without regard to immigration status. And that covers any time a patient's health is in serious jeopardy or results in impairment of a serious bodily injury or part. Many victims will get this for injuries related to the victimization. They all can be covered by emergency Medicaid. What can also be covered by emergency Medicaid is childbirth, but not prenatal care. And that this includes emergency Medicare is available to cover COVID-19 testing and treatment. So eligibility for health care generally comes from, as I said, migrant health services, and then they can get it through emergency care, and there are Families First Act payments for coronavirus tested, anybody who's uninsured. So that would cover immigrants without regard to status as well. And through the other eligibility, which I'm going to be talking about in a few minutes, for healthcare is unaffected by the COVID crisis. And so people who were eligible under the Affordable Care Act remain eligible. And I'll go through who that is in DC as well. From a COVID-19 and CARES Act perspective, many of the survivors you work with will be survivors who have legal work authorization and a Social Security number based on legal work authorization. If an immigrant survivor has that, then they are eligible for CARES Act payments. If they file their 2019 tax returns, which can, by the way, if they still qualify if they file them late, so they could late file and still qualify. And they also qualify for unemployment insurance. Victims don't, and there'll be many victims who have work authorization and a work authorized Social Security number. U-Visa victims on the wait list are great examples of this, who do not have legal status in the United States, but they still qualify for all of the CARES Act unemployment benefits and payments if they're paying taxes. So if they file their taxes. In terms of unemployment insurance, immigrants have to have legal work authorization and a work authorized Social Security number at the time that they were working and then lost their job. So at the time that they qualified for unemployment by working, at the time they apply for unemployment benefits, and while during the whole time that they're receiving unemployment benefits. So usually once victims under the VAWA remedies, the VAWA and the T and the U-Visa and SIJ, once people get work authorization, they keep it. They're able to renew it throughout the process unless their case is denied. So it's important to stay on top of the cards expire, and sometimes you have to reapply for them, but the status, the eligibility doesn't. So it's important to stay on top of making sure the clients have their cards and apply for whatever renewals they need to do and be up to date to get these benefits. So we're going to move on now to legal right to access shelter and transitional housing. Another poll, please. If you've worked with an immigrant victim who's been turned away from transitional housing in DC or let's say Maryland or Virginia, can you tell us why they were turned away? And these are the choices. They did not have legal work authorization. They were turned away because of immigration status. They were turned away because they couldn't prove self-sufficiency, or all of the above. I'll give you a second to answer that. It looks like most of you that have had this happen are saying all of the above. Okay. Numbers are still coming in. Okay. I think that gives us an idea. We can end that poll. Thank you. So that what we're seeing nationally is the same, is that there are the main reasons that people are wrongfully denied work authorization who are immigrants is it's because the programs are asking for this information that they should not be. And I'll go through in a little bit this in a little more detail. So that emergency shelter and transitional housing programs and all of the programs that all the services those programs offer are available without regard to immigration status to all victims of domestic violence, sexual assault, stalking, dating violence, human trafficking, child abuse, other forms of abuse that are included in the U visa, and as well as homeless, runaway, people who are homeless, or runaway or homeless youth, or abandoned children. So there's a wide range of immigrants that are eligible for transitional housing and shelter, emergency shelter, that are often turned away. We saw high numbers of sexual assault victims, high numbers of trafficking victims in particular being turned away, also some significant numbers of domestic violence victims being turned away. There was a letter issued that is still current law, and that actually basically summarizes the law as it has existed since the 1990s. That was reconfirmed in August 2016, that housing providers can't turn away based on immigration status victims from emergency shelter, transitional housing, or rapid rehousing. And that is the same is true whether when they receive Violence Against Women Act funding from the Office of Violence Against Women, Family Violence Prevention and Services Act money, VOCA money, or money from HUD. It's all the same. They're not supposed to be turned away. And that includes from HUD, this is from the Office of Special Needs that goes through all of the programs, specific programs that fund transitional housing that don't have immigrant restrictions, which include all of these: home, safe haven, rapid rehousing, outreach services, emergency shelters, etc. And that there are also anti-discrimination provisions that if immigrants are turned away, it is wrongfully turned away from these programs, the programs could be charged with discrimination and could lose their federal funding if they continue these practices. And this is the law around that. I will just mention the only exception. There are a small minority of transitional housing programs actually provide direct rental assistance to individuals, and those programs could have immigration restrictions that might require a particular immigration status that VAWA self-petitioners, T visas would qualify for, and SIS, HAS children or U visa victims with lawful permanent residency would qualify for. Okay. So now I'm going to show you kind of how benefits grow over time. So when you have a victim who begins, so what I've gone through so far, just to reemphasize, is what everybody qualifies for without regard to immigration status. Everything I've been talking about in terms of benefits up till now in this benefits section is open to everyone. So now we're going to show you what else people get. Who are the immigrant victims when they start applying for immigration status? If they are screened early and apply early, then they can begin to get additional benefits beyond what I've been talking about. So qualified, they become under the term of law is qualified immigrant under benefits and immigration law. And those include people who are lawful permanent residents, and that's when, like, so if you applied for a U visa or if you applied for special immigrant juvenile status, the point at which your client becomes qualified is when they get lawful permanent residency. Refugees and asylees are eligible as qualified immigrants when they are granted refugee or asylee status. VAWA self-petitioners, they get this status 3 months after filing. Trafficking victims get it about 3 or 4 months after filing when they get that HHS letter, either because of continued presence or because of a bona fide determination. The people who are not eligible for federally funded benefits include, but could be eligible depending on the state for some state-funded benefits, include asylum applicants, DACA, U visa applicants, people who are on work visas or student visas, and people who are undocumented. Generally speaking, that group of people have the least access to benefits. Even state-funded benefits they don't usually get. It's quite limited. So let's go, now what I'm gonna do now is I'm gonna focus for the next few minutes on the qualified immigrants and what they get. And this, for VAWA self-petitioners, trafficking victims, asylees, refugees, and U's and SIJ who have lawful permanent residency. And what benefits they get depends on which of those statuses, thinking about that chart I showed you. When they entered the United States, people who came in before 1996 have more access to benefits than people that came in afterwards. The two groups of people that if you're working with the elderly, you'll see people who've been here that long and that may actually have more access to benefits. And also if you're working with, people in their 20s, because they're people who might have come in as infants, who are young, who didn't have legal status until they filed their VAWA self-petition, but have been here so long that they can skip the 5-year bar to TANF. So you want to look, people in their 20s, maybe early 30s, and people who are elderly are the ones where this date of entry might give them more access to benefits. There are heightened program requirements. There are some programs that are harder to get than others. Luckily in DC, healthcare is not one of them. And then the benefits, as I said, vary by state, and I'm going to go over what is available in DC. But first I'm going to talk about what a federal public or a state public benefit is. And that is, it's as a matter of law, the only programs that have immigrant restrictions are federal or state public benefits, or federal means tested public benefits. And that is when you're only a federal benefit if the payment, the money, or the housing voucher is going to an individual, a household unit, or a family eligibility unit. So if the money goes to pay, to pay a landlord directly from the federal government to the landlord, the money is a grant to a shelter or a program, then it is not a federal public benefit. It's not a public benefit. And these are the kinds of things that are generally federal public benefits: retirement, health, disability, post-secondary education, public and assisted housing, food stamps, welfare payments, etc. And this is the list of the qualified immigrants. And I showed you another version of this earlier. But basically, you're going to be looking at people who are lawful permanent residents, VAWA self-petitioners, which is the persons who have been battered or subject to extreme cruelty by a U.S. citizen or lawful permanent resident, spouse, or parent. It can be a self-petitioner. This can also include, this is broader, this can include those cases where the perpetrator filed an immigration case for the victim and that has been approved, and the victim didn't file a VAWA self-petition even though they're eligible, or SIJS, even though they're eligible because they're banking on getting their immigration status through the perpetrator. If the perpetrator's case has been approved, there's a way for that victim without filing VAWA to be a qualified immigrant. And we can, if you have a case like that, give us a call and we can walk you through it. So when survivors become eligible for public benefits, this is that checklist I was telling you about, and this is what the pieces of paper they'll have with you. They'll have a prima facie determination letter. They'll have an approved visa petition, or they'll have they'll have either a prima facie or an approval of a self-petition cancellation or suspension case or a battered spouse waiver case. Trafficking victims will have a bona fide determination or an approved case or continued presence. And U visa SIJS children will have their lawful permanent residency. And there are significant timing differences between all this. So what these people, if you're a qualified immigrant, what do you get in addition to what we were talking about before? You get public and assisted housing, supportive housing for the elderly disabled, post-secondary educational grants and loans, access to subsidized childcare. So childcare is one of those things that there is childcare development funded childcare that is open quite broadly to everyone, where those are programs that have an educational focus, and they really don't have immigrant restrictions. But TANF-funded childcare, which is another source of the funding for childcare, does. And so once your VAWA self-petitioner is a qualified immigrant, she can get subsidized childcare in addition to what she might have gotten before. Or she can, a VAWA self-petitioner or a trafficking victim, a T visa victim, or let's say somebody who's now in their 20s that got healthcare, that got their status through special immigrant juvenile status, they can become a foster parent and get the payments to be a foster parent. There's more FEMA disaster relief available, including unemployment for people who are qualified immigrants. There's job opportunities availability. They can get adoption assistance. There's disability benefits, and but these are the things that come generally for all qualified immigrants. And I know you think there are definitely things missing from this list, which we'll be talking about in a minute. So the last poll is, which of the following are not eligible for public and assisted housing? Lawful permanent residents, refugees, or asylees, VAWA self-petitioners, U visa applicants or recipients, or bona fide T visas? Anybody have a guess? This is our last poll. Nobody wants to try to guess? Okay, somebody guessed a T visa. Couple T's. This is who's not eligible for public and assisted housing. Okay. Okay, we got some people saying it's the U visa victims. Yep, that's growing. So we got a 50-50 tie. So the answer is, it is U visa victims. Everybody else, the T's, the lawful permanent residents, and the VAWA self-petitioners are eligible for public and assisted housing. And VAWA self-petitioners can immediately apply. This is a list of all the VAWA self-petitioners who qualify for public and assisted housing. They get it the moment they file. There is a complicated, so basically these are the instructions that you'll have to take to the benefits worker at the housing agency to apply, because what will happen is in 2016, the computer systems at DHS finally figured out how to talk to the computer systems at HUD so that they can do a verification process. So as a result, this is the way you tell the public housing authority or the landlord how to do this match system for VAWA, how to do the check for VAWA self-petitioners, and it will make them eligible for public and assisted housing from the moment they apply come in and show a copy of their VAWA self-petition. So now we're going to end on the details of DC benefits eligibility. So in DC, TANF is one of the harder things to get. It's basically trafficking victims and VAWA self-petitioners who either entered, who've been in the country, who entered before 96, or 5 years after they get their prima facie determination. U visas and SIJS are not eligible until 5 years after they get lawful permanent residency, unless they were in the country before August 22nd, 1996. Childcare, I explained. Food stamps. So what happens with food stamps is the trafficking victims get them directly. VAWA self-petitioners get them when they file a prima facie determination. The children, so any children included, under 18-year-old children included in a VAWA self-petition, or who have lawful permanent residency because of U visa or SIJ, will be eligible while they're under 18. When they're adults, they have to wait 5 years for food stamps. Education, post-secondary educational grants and loans through the federal government are available to VAWA, and trafficking victims and SIJ and U visas have to wait until they're lawful permanent residents. There's also a tuition assistance, in-state tuition essentially for DC, for UDC, that's available. In terms of healthcare, the good news is you can look at the details of this. Lots of victims will qualify at different stages, but the bottom line in DC is that DC Healthcare Alliance provides healthcare to adults who are not eligible for Medicaid. Many victims, based on this list, will be Medicaid eligible if they've started filing one of these cases, and children will be eligible under the Immigrant Children's Program in DC without regard. But if parents are able to buy insurance and want to buy insurance, they're only eligible to buy insurance on the exchanges when they're VAWA self-petitioners or trafficking victims, or U visa victims when they're on the wait list, so that's 6 years after applying. And SIJS applicants, this is the point where they bring in the application and they can purchase health care. SSI is very hard everywhere in the country, virtually unavailable unless you're a trafficking victim or have been in the United States for a long time. I went through public and assisted housing, which I summarize here. Weatherization, air conditioning, heat, and things like that, assistance is available to everyone. Lay heat is available to VAWA self-petitioners, trafficking victims, and then SIJ and U visas have to wait until they're lawful permanent residents. DC and Maryland both have driver's licenses that are not federally recognized that are available to everyone, and that the federally recognized ID for all of these victims will come when they get their work authorization. And I did talk about the CARES Act and the recovery payments. And then final point before I go to the resources page is that immigrants all the immigrants we've been talking about today are exempt from public charge, either because of the Violence Against Women Act or because of protections for refugees, asylees, DACA holders, and SIJS children. So my last point, actually I'm going to do one more thing. We have a web library of materials that we'll send you a link to where you can get follow-up materials from this webinar. And we are available, as I've mentioned a number of times through the training, for technical assistance. So please do call us when you have questions. I know this sounds a bit complex, but we've made a lot of tools to help you navigate for your clients and to steer you easily and quickly to which clients are eligible for which public benefits, because your training and your knowledge is so important, because one of the things we know nationally is, from the research nationally, is one of the biggest barriers to immigrant victims being able to access things like transitional housing and the other benefits and services they're eligible for is that the victim advocates or the lawyers don't know they're eligible. And so you're here today, and we're very excited to see so many of you turn out, and we hope this has been really helpful to you in your work, and we wish you really good luck in your work, and that hope you all stay safe during these unusual and interesting times. Thank you so much for attending.